appearances from counsel.
Judge on behalf of the people.
And police court, Robert Champion appearing on behalf of Mr. Crosby, who is seated to my left, Your Honor.
All right, thank you. I'm taking a look here at the PSI. I don't think I had any corrections that I noted. Let's turn it over to Mr. Denham. Sir?
Thank you.
Oh, wait, I'm sorry. The sentencing date at the top on CFJ 145 needs to be changed because originally we were here back on February 27th, but we adjourned it to allow him to be considered for sobriety court. All right, now it's up to you.
Yeah, take care. On that particular point, Your Honor, a couple weeks ago, 3 weeks ago, we did receive word that the defendant had been accepted into sobriety court. And there's been, I guess, trying to think of the respectful way of saying it, but there's been a lack of responsiveness from sobriety court in terms of actually the middle process. I'm just being very forthright without intending to be disrespectful, but
It's not my court. I got it. I know what you're saying.
okay, so I did want to acknowledge that. I mean, I did feel as if the defendant would be a relatively good candidate. We received the acceptance. And then I followed up with another email last week. Typically what happens is there's substance abuse assessment that's received as long as some initial paperwork, and I didn't receive any response. So I feel like I should acknowledge that that's somewhat in limbo. I'm not, I'll just leave it at that. But with respect to the specific question of the court, I reviewed the PSI report. I do not have any proposed corrections, additions, or deletions.
All right, Mr. Campion.
Mr. Denhouse is correct, Your Honor. Mr. Crosby has been accepted in the sobriety court. He has been presented to the sobriety court team, and they thought he was a good candidate to enter the program given his age. I understand that he's had some issues in his past, but since he has been bond in this matter, he's taking this very seriously. I believe this would be a good opportunity. So the court's aware, it's my understanding, is sobriety court is waiting to hear what this court's going to do before they give us any additional information. So we're sort of stuck between two spots. We've been notified that he's been accepted. He's been told to contact sobriety court after today's sentencing to see how it's going to proceed. But with that,
Hold on. When I said it's not my court, I knew that. And I was just trying to say that, Mr. Denham, you're not offending me. However, I'll switch and say that I've talked to sobriety court recently, that judge, and I understand there have been some issues and may have slowed some processing down, but I accept therefore the letter from the case manager for the program as for whatever it says. So I've got it. I'm not worried about it.
okay, thank you. So with that, Your Honor, I have no other additions, corrections, or deletions to the report.
Elocution, Mr.
Your Honor, my client has shared with his community his issue with alcohol. He has strong support from his family, from his employers, and more importantly, Mr. Crosby is committed to his sobriety. I believe this would be a good opportunity for a young man who does not take this chance seriously. Will be in the Department of Corrections shortly. So with that, I would ask the court to grant my client the opportunity to enter sobriety court and enter into late sentence. Thank you.
Thank you. Mr. Denham.
Thank you. This incident occurred on October 15th of last year. It was a traffic stop, no registration, no insurance. There was an active warrant at the time. He was on probation, I believe, for the defendant's prior impaired driving. So that's a negative. On the positive side, he was cooperative with law enforcement. Another thing that I want to say is that I don't know if he's here now, but it's my understanding the defendant has been working with local business, after local business, Rusticaga. The defendant's employer has been at a series of the prior hearings. I don't know if he's here today, but so he does have support. As I indicated, I thought that he's a good candidate, whether it's sobriety court or a different treatment program through the probation department. I do believe that he's a good candidate for rehabilitation. And I would also ask, given the fact that I believe he does have community support, is a hard worker, I would ask the court to consider possibly, if it meets with the rules of the sheriff's department or the jail here, that he be allowed to participate in work release. And with that, I'll leave it to the court, Your Honor.
Thank you. Mr. Blazek, I'm sorry, I did catch, I think, one small correction. It's just a number. It's back on CFJ 284, page 8, underneath finances, next to the words income narrative. You say that he reports income of $50 a week. I think that's $250 because right above it, that's what it says. So I just think you're missing it too.
Yes, Your Honor.
All right, thanks. All right. Mr. Crosby, anything you wish to say? You can remain seated. It's fine. Is there anything you wish to say before I give a sentence? How many hours a week do you work?
35.
Right. Thank you. Right. So I'm going to ask Mr. Crosby some questions. Why would I send you to sobriety court when you were on probation for your last drinking and driving? And you knew there was a warrant. You intentionally didn't turn yourself in, and so you decided to go out for one more night of drinking. And you were operating a vehicle knowing that you didn't have the license to do so. And, which of course was a violation of your probation. And that you're operating a vehicle without any insurance and without any registration. Knowing that you were on probation and knowing that condition number 1 of your probation would be that you can't commit any crimes, and knowing that you can't consume alcohol, and knowing that you had a warrant, why would I put you into the sobriety court program? You do it.
I'm not sure, Your Honor. The only way I can show you that I'm serious is to prove it to you.
I'm going to tell you, you're going to get to prove it to me because I'm not going to put you into the sobriety court program. You were on probation for drinking and driving. Whose car were you driving?
It was mine, Your Honor. It's been repossessed.
So now you make, if the numbers are correct, roughly $12,000, $13,000 a year. You live with your father. You can't pay your bills for your car, but you can afford to buy alcohol and marijuana, but you can't even bother to go out and drive a car legally. What else you spending the money on? I know it's not a lot of money, but what else you spending the money on? Okay. I know you're shaking your head. I got it. And you're 28. So and in the last 10 years, since you graduated high school, I don't see any college. I do see you went to a tech program. Actually, that was before you graduated high school. So it was a culinary arts program. That means from 2016 until you at least got the first job I see listed here. Oh, it's 2000. Oh, you're working at Taco Bell, but you finished that when you were done graduating high school. So it was about 6 years before you got another job. In it, you worked at less than oh no, you worked for 2 years and a month. Then you had a year off before you started working at the barbecue. One moment. See what your criminal history is like. So we had a bond violation history here, at least in this case, just with a showing up late for a testing. Okay, and then he failed to show up for testing on another date. And I did like this quote, and I put a star next to it, because to me, it is the theme of this case. On CFJ 284, page 1, it says, you have to read the rest of the paragraph, but or actually, I'll read the 2 sentences. His recent history of noncompliance with district court probation and his apparent continued noncompliance with bond is concerning, period. It does nothing to inspire confidence in his ability to successfully complete a period of community supervision. Mr. Blazak, that's one of the best 2 sentences I've ever read in a pre-sentence investigation report, because it's exactly what I thought. Oh. And I also noted here that when the officer stopped you, there was a strong odor of alcohol. So he could clearly tell you had been drinking. So, no, you continue to do what you wanted until you got caught. Prior criminal history began in 2020 as an adult with a careless driving. All right, not the biggest crime. It took you about a year, and then you got in trouble again with your first drinking and driving in 2021. Well, they only gave you 3 months of probation. 10 weeks later into that, you violated probation. You already violated probation in your first big case. Now that was just a careless driving, but all right. Then you made it about 6 weeks after being discharged from your probation in 2022, before you picked up operating with an open intox. So not learning the lesson, you didn't get into jail. You had a 3-year gap until 2025 when you picked up your other drinking and driving. That was handled down in the district court. And of course, you had the instant offense that caused you a probation violation, and your probation was terminated. You were only 3 months into your 6-month probation. So I can think of nothing other than the message of deterrence. The message of deterrence is to go through the probation officers. So when people drink and drive, especially young people who think they can skate through it, but young, you're still 28. So no, there's a deterrent message. You're on probation, you follow the rules. Pretty simple. Don't drink, don't violate the law. Oh, and you'll be successful. You couldn't even make it halfway through it. So this court is going to say that the message here today is deterrence. Rehabilitation will be taken care of through probation, but it will not be taken care of through sobriety court, because you shot your foot. Sorry, bad choices. You now have your first felony conviction at the age of 28, all because of alcohol and your continued violations of bond and probation. I'm very sorry that you made that choice, but you did. The sentence of the court is that the defendant is placed upon a period of probation for 24 months. I adopt the terms, actually 36 months is what I meant to say. 36 months, the court adopts the terms and conditions that are listed on CFJ 145, pages 2 and 3. I find that those are well suited for rehabilitative purposes, considering all the factors that I've discussed. The court assesses a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 court cost for the processing of this case, a $300 attorney fee. I'm going to assess a $1,000 fine, a $30 a month for supervision, or $30 a month, $60 a month, I'm sorry, if there's any electronic monitoring. And the court assesses a $60 DNA fee.
Yes, sir.
That's payable to the Missaukee County Sheriff.
Yes, sir.
Payable to Missaukee County Sheriff. So the last question here is what do I do with the defendant here for any jail time? Well, the guidelines are up to 6 months. However, there's reasonable grounds because it's repetitive alcohol violations and he was on probation. So I've already covered that, plus probation or bond violations. So the question becomes, how much, if any, do I give above the statutory required minimum? Court sentences the defendant to a 60-day jail sentence with 13 days of credit. Oh, hold on. Let me just think. I forgot about that he had the 72 days for the court for the probation violation. I think. Well, while the defendant's not statutorily required to it, I'm not going to give any further credit. I'm going to go with the 60 days as already set forth. Have I missed anything, Mr.? Oh, and I don't need to do the mobilization because the vehicle's been repossessed. Anything else, Mr. Blazak?
I don't believe so, Your Honor. Thank you.
Mr. Denham?
I don't believe so, Your Honor.
All right. Mr. Champion has probably given to you 2 copies of one document. You've initialed yours, maybe not.
Unfortunately, this one I did not. Your Honor.
All right, well, Linda, I need 2 copies. And by the way, throughout today's files, and I don't say this to be negative, I'm only getting either 0 or 1 copy of those in the files.
I didn't have them in the file because if you went on delay, they
Oh,
have been.
I got it. I'm just letting you know.
But-
Okay.
Give me one moment.
Hey, I'm not going to force you into retirement.
And I have to run and get them because they don't print down
All
here.
right, thank you. Madam Clerk is going to bring back to us 2 copies of one document. Mr. Champion will give them to you as you go over them. The first copy, you're going to place your initials on. Doing so neither elects nor waives in your rights. It merely acknowledges your receipt to the copy of the document. Now, this document tells you that you have the right to appeal the conviction and sentence in your case. And that is typically done by filing a claim of right to appeal. However, based upon the original plea in this case, any appeal is done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the copy that Mr. Champion will give to you. You may return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Again, while this is an intermediate sanction, still the court finds there to be reasonable grounds, and the court finds the sentence is reasonable proportionate based upon all the factors that I've considered. You are a very, very, very young person, Mr. Crosby, and I did not give you much of a jail sentence. I gave you some. Oh, by the way, it's a first felony. Linda, it's the first felony, so it's got to say 60 days to 60 months on the judge. All right, thank you very much. And Mr. Champion is now returning to me that 1 copy of the advice of rights with the initials. Linda, right here. Mr. Crosby, stop acting like a kid. You're 28 years of age. You can put all this behind you, and I hope that you do. We are adjourned.